All right, we're going back on the record, CR 21147, the state of Texas versus Samuel Adam Turner. Mr. Turner, if you'll please rise. Mr. Merleader. Mr. Turner, I've considered the evidence in this case. I've considered arguments of both Mr. Merleader and Mr. Woodwhite. I've spent a lot of time considering that over the lunch break. It's not an easy decision to make. It's one that I don't take lightly. In reviewing your case, I put a lot of weight on your testimony about your testimony where you said that you changed, you've quit drinking, that you, according to your PSI, you haven't had alcohol or marijuana since that incident date in 2020. I listened to you sincerely and genuinely, and I believe what you say, in that you're trying to embrace who it is that you're supposed to be. I liked specifically what you said about if these are the shoes that are being given to you, you got to lace them up and you got to walk in. That was pretty impactful. It's pretty impactful. In considering your case, I've also looked at your history. That's something obviously I cannot ignore. It's quite lengthy. And I'm dealing with the same issues that other judges have dealt with you in the past for your alcoholism. And I think you should be commended for taking the stand and admitting that you have a disease. And but unfortunately, I'm having to deal with the same issues that they were dealing with over 20 years ago. So the way I consider whether or not I should give someone probation is I have to ask myself, is this in the best interest of the individual? And I think it would be in your best interest. I think it would be in your best interest. That's not a difficult question to answer. But unfortunately, there's a second prong that I have to answer. And that question is it not only in the best interest of Mr. Turner, but is it also in the best interest of the community? And unfortunately, I think that's a more difficult question, because I do have concerns. I would have concerns about your ability to handle, and you said that earlier, you haven't handled it yet, it's been handling you. I would have concerns about whether or not you could handle your alcoholism while you were on community supervision. That's something I really had to think through over the lunch period. Unfortunately, I'm not going to grant your request for community supervision today for probation. And I felt like you were owed an explanation as to why. And this is not an offense that we could ascribe to youthful indifference or lack of wisdom or lack of experience. Unfortunately, as you said, it's taken you 60 years to get to that point. So, Mr. Turner, based on the evidence, court having already found you to be guilty of driving while intoxicated, third or more offense, the court having found the enhancement paragraph to be true, court hereby sentences you to 5 years confinement in the Texas Department of Criminal Justice Institutional Division. I will not issue you a fine, but I will order you to pay court costs, and you will be given credit for any time that you have spent in jail on this cause. Mr. Merleader, is there any legal reason why sentence should not be pronounced at this time against Mr. Turner?
No, Your Honor.
Mr. Turner, do you have any questions? So, Mr. Turner, you're going to go into custody at this time. Okay. So I'm going to have the deputy come over, and if Deputy McLeish is okay, if you want to talk to your pastor at all before you go into custody, I'm fine with that. Okay. I wish you the best of luck, sir.
Your Honor, I've counseled Mr. Turner on his right to appeal and his right to appellate counsel. At this time, I'm asking the court to permit me to withdraw, appoint appellate counsel for Mr. Turner. I'm not certain if he wants to appeal the decision, but his appellate counsel can at least speak to him about that and let him make that decision in 30 days. Or in turn, if the court wants to keep me on for another 30 days, I can counsel him on that. And if he wishes to appeal, I can relay that information to the court.
I would rather do that if you don't mind, because typically my procedure is I wait for a notice of appeal, intent, or a motion for new trial, and notice of appeal, and then I would appoint appellate counsel Having not heard him say that he wants to appeal, I would automatically appoint him an appellate attorney at this time. So I won't discharge you today. I will sign your invoice today. And then once that 30 days has elapsed, if whatever decision that Mr. Turner makes, you'll let me know. And then at that time, I can discharge you as attorney. Thank you, Mr. Earlier. Mr. Woodward, is Ms. Abney going to be able to prepare the judgment today? Yes, Judge. Thanks, sir. Mr. Stevens or Mr. Ashmore, either one of you ready to go?
I'm ready on Mr. White.
Mr. White, if you'll come forward, sir. Kenneth Dwayne White, CR 17-217, CR 19-32.
Judge, just for the court's records, in CR 19-032, the court's docket says the assault and deadly weapon only was. It was previously fled down to a misdemeanor assault. Just so the court is not confused, because when I first looked at it, I was confused as to what we're talking about.
Thank you, Mr. White.
Judge, you want to be the podium over here?
No, he's fine right there.
Okay, he's fine.
All right, Mr. White, if you'll raise your right hand, sir. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. You are Kenneth Dwayne White, is that correct?
Yes, sir.
Mr. White, in CR 17-217, you appeared before the court on August 6th of 2019. And you pled guilty and were convicted of possession of a controlled substance of penalty group 1, less than 1 gram, a state jail felony. Court heard the evidence, assessed your punishment at 18 months confinement in the state jail division of TDC, ordered you to pay a fine. And then the court then suspended that sentence and placed you on community supervision for a period of 3 years. CR 1932. You appeared before the court on that same day and you were convicted of a Class A misdemeanor assault that causes bodily injury. Sentence was assessed at 1 year confinement in Lansing County Jail. That sentence was suspended and you were placed on community supervision for a period of 2 years. Mr. Stevens, does your client waive the formal reading of the state's motion to revoke in each case?
Yes, Your Honor.
Is it his intent to plead to all counts in each motion?
Yes, sir.
All right. And Mr. Stevens, do you believe Mr. White to be competent today to enter into this plea agreement?
Yes, sir. I did.
Mr. White, are you pleased with Mr. Stevens as your attorney?
Yes, sir.
Do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered?
Yes, sir.
Anything about the paperwork that you don't understand? All right. Mr. White, then I'm going to ask you at this time, how do you plead with regards to the possession of controlled substance case wherein the state has alleged in its motion to revoke 11 separate counts? How do you plead to counts 1 through 11? Well, do you plead true or not true? True. And with regards to the assault case, the state has alleged 7 counts of ways that you have violated your community supervision. As to counts 1 through 7 in that case, how do you plead to those? True or not true? True. Mr. White, are you pleading true to all of the allegations alleged in each case because each allegation is true? Has anyone threatened, forced, or pressured you to plead true to any of these counts in either case? Court will accept Mr. White's plea of true to each count. Mr. Stevens, any objection to the state's evidence?
No.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No.
From the defense?
No, Your Honor.
Mr. White, your signature as it appears in this document, is that your true and correct signature? And you only sign once you were satisfied that you understood what you were signing. All right, Mr. White, court has reviewed the evidence. I do intend to follow the plea agreement that you've reached with the state in each case. Court hereby finds that you have violated the terms and conditions of your community supervision in each case. The court in CR 17-217 hereby revokes your community supervision, assesses your punishment pursuant to the plea agreement at 8 months confinement in the Texas Department of Criminal Justice State Jail Division, and orders you to pay the balance of your financial obligations, including your fine, court costs, and restitution. Court awards you 84 days credit on that sentence towards the time that you have spent in jail on that cause. With regards to the assault causes bodily injury, CR 1932, court hereby revokes your community supervision, assesses your punishment at 85 days confinement in the Van Zandt County Jail. Court awards you 85 days credit for time that you've spent in jail on that cause, and orders you to pay the balance of your financial obligations, including court costs and reimbursement fees. Mr. White, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to step forward and be fingerprinted. The deputy, please. All right, are you ready on McPherson? I am. Dylan McPherson, you'll come forward, sir. It's a CR 1945, State versus Dylan Kyle McPherson. Hearing on motion to revoke, Mr. Stevens.
Yes, Your Honor. Judge Boomer asked for a note agreement. This is also sports safety. I have received them all from the state. We do think we're going to reach it for as much. However, we would ask for a note agreement that this offers time. If we're out of 2020, we would need some more things.
Any objection to the state, Mr. Woodwine?
No, Your Honor.
All right, court will reset Mr. McPherson to February 24th at 1:30. Sorry. You want these orders?
The jail is apparently overcrowded since McPherson County had COVID outbreak.
Your Honor.
Oh, Mr. Bacon, we're getting some papers sent over, plea papers, and we'll be pleading in just a few.
Okay. So we didn't bring over Sherwood. pressured you to make you feel like you had to plead true to any of the counts in the state's motion?
No, sir.
All right. Court will accept Ms. Heidel's plea of true. And there's no agreed evidence at this time. Is that correct?
That's correct, Your Honor. State would offer the state's motion to adjudicate. The state's one as far as punishment goes, and ask the court to take judicial notice of that.
Any objection to offer the state's evidence? All right, state's evidence is admitted and court will take judicial notice of Ms. Heidel's judicial confession. State, do you have any witnesses you want to call?
Your Honor, the state would rest as to the matter of adjudication. If the court would like us to proceed on with punishment, we can do that at this time, or if the court would like to pronounce on adjudication, I'll defer to the court on that.
Pull our motion up again. All right, so the court, having accepted Ms. Heidel's plea of true, the court finds that Ms. Heidel has violated the terms and conditions of her community supervision. The court hereby adjudicates her guilt and convicts her of the third-degree felony offense of tampering or fabricating with physical evidence with intent to impair a third-degree felony. Anything further with respect to adjudication?
No, Your Honor.
Anything further from the defense on the adjudication?
Your Honor.
All right, so as to punishment, state,
Your Honor, the state would waive opening as to punishment.
all right, any punishment witnesses?
No, Your Honor.
State rest, just reserved for closing.
Correct, Your Honor.
Mr. Ashmore, do you want to call any witnesses on behalf of Ms. Heidel for punishment?
I'd like to call Ms. Heidel.
Ms. Heidel, I'll tell you what I'm going to do. I'm going to let you testify from there,
Yes,
but is there another microphone?
Here, she can.
Put this one right here in front
And
of
then,
her.
and then we'll bring another one here.
Okay.
I'm going to do this so long as, Mr. Ashmore, you and Ms. Heidel don't talk to one another, that y'all talk to me so I can hear. So if y'all turn to each other, it's going to be hard for me and Ms. Christian to hear. So make sure you talk loud enough. Otherwise, I'll need to bring her up here.
Okay.
So when you answer, look forward, okay?
All right, Ms. Heidel, if you will, raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can put your hand down. Go ahead, Mr. Ashmore.
Thank you, Your Honor. Ms. Heidel, you and I've been your attorney since 2019, right?
Yes, sir.
Okay, and this is a 2015 charge.
Yes, sir.
You're not wasting the state's time proving that you didn't violate, are you?
No, sir.
Okay. What impediments to your ability to comply physically do you have right now?
Physically, I have Parkinson's disease, and I have valve leaking in my heart. I've had a stroke and had to learn how to talk and walk again. And I have Crohn's disease. I need help of getting dressed and stuff. Can't take care of myself.
Okay. And these are the exact same physical problems you had in 19, aren't they?
Yes, sir. I've gotten a little worse on the Parkinson's.
Right. I noticed and the shaking and what have you is from the Parkinson's.
Yes, sir.
And the shaking and your ability to ambulate physically has gotten worse since 2019.
Most definitely.
Okay. So your ability to comply with the terms and conditions of probation, was that a willful violation?
Well,
Were you intentionally blowing the court off?
No, sir.
Were you intentionally blowing probation off?
No, sir.
Did you voluntarily surrender in 2019?
Yes, sir.
And were you discharged at some point?
Yes, sir.
And then with a stipulation to not rearrest, as you understand it?
Yes, sir.
And then later somehow that was withdrawn and you were rearrested?
In 2020, I turned myself in I went into cardiac arrest in the lobby and I had to call an ambulance. They gave me paperwork saying that I had to do not detain for medical. And that was in my boyfriend's left compartment in his car that got stolen. And
Okay, hold on.
sorry.
Let's answer the question.
Okay,
So the answer is yes.
yes.
Okay.
Sorry about that.
Yeah, no problem.
Yes.
So the medical paperwork related to that, you do not have.
No, sir.
Okay. What's the inhaler for?
I've got congestive heart failure and COPD. My dad had the same thing.
And-
Hereditary.
What's the maximum amount of physical labor your doctors say you can do in a day? If any.
I'm just supposed to have a caregiver. I can do what I feel like I'm able to do.
Can you put on your shoes by yourself?
At times I have to have help, but at times I can do it by myself.
Okay, can you put your pants on by yourself?
At times,
What about your undergarments?
yes, sir, I can, but I no, I do have to have help. I do have to have help.
Okay.
Yes, sir.
Now, you know that you've had an offer at one point of 2 years prison time on this offense, right?
Yes, sir.
And the same or similar health conditions were an impediment to you performing on probation then as now?
Yes, sir. My husband also passed during that time. He helped me get around and stuff, so,
So between 2015 and 2022, your husband passed?
yes, sir.
I'm very sorry about that. Bless you. Was he your caregiver?
Yes, sir.
And do you have anybody to help you get to and from places like your husband?
Now,
Yes.
yes, sir, I do.
Who would that be?
My boyfriend or I have a friend that will help me.
When's the last time you were able to physically work in any office or physical environment?
Around 2015.
Okay.
I applied for disability at that time.
I apologize, Your Honor. I was unable to hear Ms. Heidel's response.
I'll re-ask, but I think she said 2015 and she applied for disability. Let me ask the question so it's appropriate. The last time you were physically able to work, you said 2015,
Yes, sir.
and then after these diagnoses of Parkinson's, COPD, heart failure, et cetera, stroke, you applied for disability.
Yes, sir.
Did you get approved for disability payments?
That is in the works right now. I went to jail and it got put off. I did my hearing and so I had to reapply recently.
So right now you have no disability benefits,
Not yet.
but you think you might if you are discharged.
Be qualified, yes, sir.
Any other income or resources?
And I just have family that will help me until I get it. Yeah.
Judging the thought of not belaboring this, I'm going to pass the witness, subject to maybe any request or redirect, excuse me.
Heidel.
Miss Heidel, when did you suffer your stroke?
In 2019,
Okay,
I'm sorry, 2017.
2017. Okay. And you have pled true to missing 5 of your probation appointments in 2018.
Yes, ma'am.
Were any of those tied to medical reasons?
Yes, ma'am.
How many of those?
So, gosh, probably 3.
Okay. And did you ever, who was your probation officer at that time?
Larry Gann, I stayed in touch with him, but I had to leave messages on his voicemail a lot because I couldn't get him.
And did you ever provide Mr. Gann with any medical documentation from those missed appointments?
Yes, ma'am.
Okay. And then it looks like after October of 2018, you just stopped reporting after that. Is that correct?
Yeah, yes, ma'am. That's when my husband died. The month before that.
In September of 2018? Your Honor, I would pass witness.
Mr. Ashmore?
Nothing further, just respectfully request to address the court closing statement.
How long has Ms. Heidel been in custody on the state's motion?
There's 2 periods of custody, and I don't have the total count. I was on my way to the jail, and Ms. Tabor called me and said we're here today. So in
Actually,
19, she was in. Go ahead.
I'm
Steve.
sorry.
No, it's all right. Go ahead.
Actually, from the beginning, I've done about 9.5 months.
9.5 months?
Yes, sir.
That's both periods?
Yes, sir. Well, actually, there's 3. The original charged, motion revoked, and this.
And all 3 are about 9.5 months total?
Yes, sir.
Any further witnesses, Mr. Ashmore?
No, Your Honor.
State, no rebuttal.
No, Your Honor.
State, do you want?
Your Honor, state would reserve until the conclusion of defense counsel's closing.
Mr. Ashmore?
Judge, I think we're all in a different place in 2015. There was a different judge here. The world was different. We weren't locked down for 90 days, told we couldn't come to work. And certainly my client, whose health has gotten worse, it's been 7 years, and her Parkinson's, her health conditions, which are visible to the court, and visible to me as her attorney, she looks way worse than when I had the privilege of being appointed to her at 19. And we were our first time at the Van Zandt County Detention Facility when Mr. Manning was still the district attorney on this case. And I'm not saying this is a victimless crime. It ain't. We're here on bended knee with penitence, asking the court for some resolution here because the state, which is not, and graciously not putting up a heck of a fight against a lady who's clearly very ill, but we don't know what the fix is. So we're here asking the court for that guidance. I know she's had an offer. You've heard her testify that she has had an offer as low as 2. And again, it's these physical conditions about knowing that your physical body is shutting down with Parkinson's, which is what happens. It's a degenerative, you're swirling the drain disease where you physically get less and less able to walk, put on shoes, talk. It's a matter of time before she's in a wheelchair. And so we're just asking the court for mercy in light of a tampering charge. And we understand the noncompliance. It's not something to be dismissive of, but it's also not willful contempt of the court's conditions of probation. It's certainly not thumbing the nose at the court. It's inability to comply because of physical health limitations. So we appreciate the court at the time today.
So, Mr. Ashmore, are you asking that Ms. Heidel be placed back on community supervision? Or are you asking that she be sentenced to the minimum? What exactly are you asking the court to do? And I'm gonna, in fairness, I'm gonna ask Ms. Heidel the same thing this time.
Judge, I think that she's done 9 months at the Van Zandt County Detention Facility. The state and I can't come up with an agreement on how to resolve her case because of her physical limitations. If jail time is a condition of a sanction, but her sanction, the court should consider a sanction because again, at this civil burden of proof level here today, right? Just a greater weight of the evidence before the court. The question then is sanction appropriate? That's totally up to you. Level 1, 2, 3. The court can make jail time a condition of take up her back time, put her back on probation, maybe a fast track to complete this. But with her continued degenerative situation, I don't know if she can. Drugs aren't the issue here. Dirty UAs aren't the issue here. It's physical inability to show up to community service hours, even as something as simple as maybe riding a golf cart on first Monday, because somebody would have to physically put her in the golf cart. And I don't think she needs to be in TDCJ. And I hope the court doesn't consider that. I don't know what the fix is, but a sanction seems the most appropriate, even if it's a sanction for jail time and some sort of fast track to finish this 2015 case, because the county's got the need for that space that doesn't belong to somebody who's medically with these medical issues, Judge.
Probation expired in July of 19, is that correct? She was placed on probation July 16th of 15 for a period of 4 years, and the state filed this motion in February of 19. So
Yeah,
she hasn't been extended, has she?
That's correct, Your Honor.
So that limits what the court can do, correct?
I didn't realize that, so I'm taking. I believe that's correct.
Thank you.
Thanks, Judge.
How's your turn?
Thank you, Your Honor. Your Honor, Mr. Ashmore and I have discussed this, and my understanding was that their request was going to be for some sort of probation with days as a condition. Frankly, Your Honor, given Ms. Heidel's medical condition, I didn't want to agree to that. I didn't want to put her in a position to sign her up for something that she wasn't going to be able to complete just because we wanted to avoid the alternative. Your Honor, the state, as you've heard, has made offers in the low range, but kind of because we haven't addressed this issue before now, because we're at the point that we're at, there aren't a whole lot of alternatives. So, Your Honor, I would ask that she not be given any term of probation. I believe that that's setting her up to fail. But I would also ask the court to sentence her to the low end of the range of punishment in this case, such that reflects such that her to be appropriate with the violations we have, Your Honor. They are correct. Her violations are mostly, if not all, related to her medical condition. She was not, to our knowledge, out there committing new crimes or abusing illegal substances or anything like that. So we would just defer to the court's judgment because Mr. Ashmore and I couldn't come to a resolution.
Have counsel approach.
Yep.
All right, we're back on the record, CR 1411, State versus Stacy Marie Heidel. Heidel.
Thank you, Your Honor. Your Honor, based on the testimony before the court today, the state is respectfully going to ask you to withdraw your finding as to Ms. Heidel's plea of true, also as to her adjudication. And the state would at this time make a motion to withdraw and terminate her community supervision.
Mr. Ashmore, I'm assuming no objection.
No objection, Judge.
All right, then the court will grant the state's motion for the court will withdraw its finding of Ms. Heidel violating the terms and conditions of her community supervision. The court had pronounced the adjudication of guilt of Ms. Heidel. The court will withdraw that. Court will at this time, with none of those being rendered, court will grant the state's motion to withdraw the state's motion to adjudicate in the interest of justice based on the medical issues before the court here today. The court will find that Ms. Heidel's community supervision is terminated. So Ms. Heidel, I've signed the order on the state's motion. So we'll send that paperwork over to the jail and you'll be processed out later. And you can thank Ms. Heisel.
Okay.
All right. It's not me. It's Ms. Heisel.
Okay, thank you very much.
Casey, if you'll go with it. Mr. Ashmore, you ready on Kareem Miller?
We have a paperwork that don't know where that is. We're ready on this. It's being printed, that we can go forward with Mr. Grubbs, Your Honor.
Mr. Grubbs, do come forward, please. All right, this is cause number CR 2164, State versus Justin Richard Grubbs, hearing on motion to revoke. Any announcement from the state defense?
Your Honor, I believe that we have an agreement as to the open plea, but no agreement as to the punishment cases.
Okay. Does Mr. Grubbs intend to plead true to all counts or specific counts?
All of them.
Mr. Grubbs, if you'll raise your right hand, I'm going to place you under oath at this time. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. You can have a seat. State, are you proceeding on the motion to adjudicate and revoke file November 2nd, 2021, wherein you have alleged 5 counts?
Yes, Your Honor.
Mr. Ashmeyer, I believe you said that, does he waive the formal reading of the state's motion to adjudicate?
We do waive that. We've gone over it multiple times and we're good with that. Don't need it to be read. We're pleading true. It's just about the issue of where we're going to fall on that punishment, Your Honor.
And do you believe Mr. Grubbs is competent today?
I do, Your Honor.
And Mr. Grubbs, are you pleased with Mr. Ashmore's representation of you?
Sure.
You feel like you've had enough time to discuss your case with him, have all your legal questions answered?
Sure.
Is there anything about this proceeding that you do not understand?
No, sir.
All right, so Mr. Grubbs, you appeared before the court on November 5th of 2020. You pled guilty to the second-degree felony offense of possession of a controlled substance of felony group 1, greater than or equal to 4 grams, but less than 200 grams. The court on that date heard the evidence, found that there was sufficient evidence to convict you. However, the court followed the plea agreement you reached with the state. The court deferred a finding of guilt and placed you on community supervision for 6 years, ordered you to pay a $2,000 fine. And it's been during the period of your community supervision that the state has filed its motion to adjudicate and revoke your community supervision, and has alleged in 5 separate counts ways they believe prove that you violated the terms and conditions of your community supervision. So at this time, Mr. Grubbs, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, and 5? Are those counts true or not true?
True.
Are you pleading true to each one of those counts because what's alleged in those counts is in fact true?
Sir.
Has anyone threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
Court will accept the defendant's plea of truth. Mr. Ashmore, any objection to the state's offer of the defendant's plea of truth? All right, that's submitted. The court does take judicial notice of Mr. Grubbs' judicial confession. Anything further from the state as to adjudication?
No, Your Honor.
For the defense, anything further as to adjudication?
No, Judge.
All right. And are you asking the court at this time to adjudicate, or are you asking me to defer a finding until I hear the evidence?
Your Honor, the state would ask for adjudication at this time.
Mr. Ashmore, is there any reason that you're asking me to defer a finding of guilt as to these pleas of truth at this time?
Judge, I am simply because we intend to put on some evidence through Mr. Grubbs that despite these violations, the court should consider something else besides an adjudication of guilt, straight probation, and or felony conviction on a second-degree felony and prison time. So for that reason only, Your Honor.
The court's going to go ahead and find that Mr. Grubbs has violated the terms and conditions of his community supervision based on his plea of truth and the evidence submitted. The court will adjudicate his guilt this date of the second-degree felony offense of possession of controlled substance, felony group 1, greater than or equal to 4 grams, but less than 200 grams. Ms. Heidel, as to punishment in this matter, do you have any witnesses you're going to call today?
No, Your Honor. The state would just ask that the court take judicial notice of the file in this cause, as well as the state's motion to adjudicate.
Court will take judicial notice of all filings in this cause and will take judicial notice of the state's motion to adjudicate. Do you want an opening argument at all?
No, Your Honor. The state would rest.
State is rested. Mr. Ashmore, would you like to call any witnesses?
Yes, Judge, I would like to call Mr. Grubbs.
All right, Mr. Grubbs, if you'll come on up. Go ahead and have a seat, watch your step on the way up. And that chair will move, so you can move closer to the microphone.
Sure. Thank you.
All right, Mr. Grubbs is under oath. Go ahead, Mr. Ashmore.
Thanks, Judge.
Mr. Grubbs, I did place you under oath. Is that correct?
Sure.
Yeah, awesome. I'll make sure.
Okay. Mr. Grubbs, you're not going to waste the state's time. You know that these are violations that you're good for, right?
Yes, sir.
And those violations, for the most part, are your inability to stay off drugs.
Yes, sir.
And regarding your performance during your probation, did you complete your community supervision, your community service hours?
100 of them within a year that I've been on probation.
So within the first year, you did 100 hours.
Yes, sir.
And what about your payments to the county?
Haven't missed a payment yet in a whole year that I've been on probation.
Do you know how much you've paid to the Van Zandt County to repay the county back?
It was like at least $1,000. That's just off the top of my head.
What was the payment schedule that you agreed to with the county?
It's $80 every month,
And you exceeded that?
and yes, sir, and then $20 court cost.
Did you check in dutifully with the community supervision department?
Yes, sir, every month.
You just can't find a way to beat the marijuana and the meth.
I just wrong people. You know, during the COVID, it was hard to find a job, but now it's finally fading away with the COVID thing. And I mean, I know I can get a job now, and as long as I get a job, get stable, then I know that drugs won't be an issue anymore.
Think you can complete the terms and conditions of any probated sentence?
Sir,
You think you'd be a candidate for some sort of successful drug rehabilitation treatment?
sir,
Is that one of the things you're asking the court to consider today? Is a sanction and a drug rehabilitation?
sir.
Judge, I mean, without belaboring this, well, let me ask you, sorry, before I pass. Before you were arrested or reincarcerated, were you working?
Sir,
Obviously, you're paying but you were working
yes.
where?
Chicken Express in Terrell,
And reporting to work how many days a week?
40 hours a week, full time.
And in that, is that where the $1,000 that you paid over the course of the probation?
Yes, sir.
Okay. How long did you have that job?
For about a year, the whole time I was on probation.
Again, Judge, without belaboring this, I'll pass the witness.
Thank you, Your Honor. Mr. Grubbs, I show that back in July 2020, when this all started, that you had 9.5 grams of meth in your possession. Does that track with what you remember?
Yes, ma'am.
And you were placed on probation in November of 2020, and then our motion was filed in November of 2021. So that's the year we're referencing here when we talk about the year you were on probation. Is that correct?
Yes, ma'am.
And your testimony is that you worked at Chicken Express for that entire period.
Yes, ma'am.
Yet you had 3 separate admissions of smoking methamphetamine during that time. Isn't that correct?
Yes, ma'am.
So having that job didn't keep you off of meth, did it?
No, ma'am.
So why is this different? Why all of a sudden is having a job going to keep you straight?
Rehab, sanctions court. I mean, anything other than, I mean, it could help. Rehab. I know it will. I just gotta get my mind right.
Is your mind right now?
Yes, ma'am. And
Mr.
ma'am,
Say that again.
and stay away from people that I was hanging out with.
Okay. How long have you been in the Van Zandt County Jail?
Since November 5th
Okay,
of last year.
of last year.
Yes, ma'am.
Mr. Grubbs, why don't you tell me a little bit about your discharge from counseling? I see here that it says based on non-compliance. What does that mean?
All it was is my last class I didn't show up to because I moved from Canton to West Point and I didn't have a ride. But I called him and told him that I wasn't going to be able to make it. But called my probation officer anyways and told him that he was kicking me out of class.
But that was the only time, that's your testimony, that was the only time that you didn't participate in those
Yes,
counseling
ma'am.
classes?
I've showed up to every one besides that last one.
I also showed that you didn't complete your drug offender education class. Is that correct?
I was in the process of getting that done.
Okay, but you were notified that you had 90 days to do that, correct?
Yes, ma'am.
And you didn't get it done in that period of time.
No, ma'am.
Your Honor, I'd pass the witness.
Joshua?
I can follow up, Judge, but I think I'd be belaboring the point. I just asked the court for an opportunity to make a closing statement.
Mr. Grubbs, you may sit down. Give any further witnesses, Mr. Joshua?
No, Your Honor.
Any further evidence at all?
No, Your Honor. Thank you.
None from the state.
You rest. No rebuttal, closing.
Your Honor, I would reserve after defense closing.
Go ahead, Mr. Joshua.
Thanks, Judge. Respectfully, I don't think I've ever had a probationer who actually did his hours, ever. And I haven't been doing this forever, but this is a first time I've had a motion to revoke with somebody who tried on the hours. And the first time I've ever had a motion to revoke with somebody who tried on the payments. And I know that's not unheard of, but it's my first rodeo on that deal. I think the catch-22 is Justin can be a model when he's being monitored, and that does worry me, right? He's already wearing trustee stripes, and he's only been in a few days. So that tells me he can perform inside, and maybe he needs something like that. But a kid who, and again, he is a kid, which is why I'm asking the court not to put him in TDCJ. And I understand this is a serious offense, methamphetamine. It's a second-degree felony, which means it's a big amount. And it's a scourge in our community in all of North Texas, right? We have the same problem. That being said, this is a young man who's addicted to methamphetamine. He needs some help, some intensive supervised probation. He's not been sanctioned, and he did try, at least when it came to some other substantial parts of the performance requirements. And that's our respectful request as the court consider some sanction, whether it's some gobble up his back time in jail, some intense supervised probation, straight probation, conviction, because the court's already made an adjudication. So we understand that means our ability to get all of our rights as a citizen are back. But on the other hand, with the effort that this young man put out and with the demon that he's fighting, which I know your Honor has seen it your entire career, but you also know how addictive this drug is and how bad addiction can be. So we're asking the court for a sanction, whatever conditions the court sees fit, ISP, rehab, what have you, to allow him to at least remain free and not be incarcerated. Thank you, Judge.
How old is Mr. Grubbs?
31.
31.
Sir.
Any children?
1.
Married?
Sir.
Thank
Your Honor, with 9.5 grams of meth, a second-degree felony, the state gave Mr. Grubbs a chance to not be a felon, a chance to not go to prison. We offered deferred on a second-degree felony amount. And Judge, the court knows, and Mr. Ashmore knows, how rare those opportunities are handed out by our office. I know, I see that this was handed down during your tenure. I know from being in this court that being in front of you, when he took this plea to deferred, the court admonished him on exactly what the repercussions would be of not succeeding on probation. Yet, approximately 5 weeks after getting those admonitions and getting this sweetheart of a deal from the state, Mr. Grubbs shows up to probation and admits to smoking methamphetamine in the past month. Not only that, Your Honor, but he showed up the next month and admitted to smoking methamphetamine again. Not only that, Your Honor, but he shows up in June and admits to smoking methamphetamine again. He also was discharged, Your Honor, for not completing his classes and not participating in the counseling sessions that he was ordered to. I appreciate the efforts that he made to pay his money and do his community service hours, and that doesn't go unnoticed, but that also doesn't override the violations that he had. And that also doesn't override the fact that it was made clear to him exactly what the repercussions of failure to perform on probation would be, and that is TDC time. Your Honor, 9.5 grams of methamphetamine is not an insignificant amount. We believe he's already been given the grace of a deferred offer, and his response to that was the first 2 subsequent months of probation showing up and telling them that he hadn't quit smoking meth yet. He's sitting here today and he's asking you to remain on probation. He's asking you to give him sanctions or drug treatment or basically anything but prison time, the thing you have already told him he would be getting if he violated probation. And Your Honor, he testified that if he could just get a job and get straight, the drugs won't be a problem for him anymore. Yet he also told us that he was working the entire time that he was on probation. So those 3 months that he showed up and admitted to smoking methamphetamine, he was doing that with the job. The job wasn't enough of an inducement for him to not smoke methamphetamine. We hear him today, but based on his history, Your Honor, we're asking you to sentence him to TDC. The grace has already been given to him, Your Honor, and we ask you to sentence him to an appropriate time for 9.5 grams of methamphetamine.
All right, the court's going to take the evidence and arguments under advisement, recess in this case, and take up some other cases, and then we'll call this case.
Yes, Judge, thank you.
Mr. Grubbs, you can have a seat back, I'll probably back up. Steve, you ready?
Yes, I am.
Mr. Madkin? All right, you're Andrew Casey Madkin, is that correct?
Yes, sir.
Mr. Madkin, if you'll just raise your hand, right hand to the best of your ability. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, put your hand down. Mr. Madkin, are you a United States citizen?
Yes, sir.
Well, I see you're already on probation, so I've already went through all that with you. In this case, you're represented by your attorney, Mr. Stevens. Are you pleased with his representation?
Yes, sir.
Feel like you've had enough time to discuss your cases with him and have all your legal questions answered?
Yes, sir.
Anything about this paperwork that you've read and signed today that you do not understand?
Yes, sir.
Mr. Stevens, do you believe Mr. Madkin to be competent?
Yes, sir.
And you've explained to him his legal rights?
Yes, sir, I have.
And does your client waive the formal reading of the state's motion to revoke?
Yes, sir, we do.
And does he intend to plead to all counts?
Judge, we're going to plead, we're not going to plead to count 1, but we're pleading to all of the counts. And I believe that's a group of the state, I think they.
State is free to abandon government.
And Mr. Madkin, where you have signed in these documents, is that your true and correct signature?
Yes, sir.
And did you only sign once you were confident that you knew what you were signing?
Yes, sir.
All right, Mr. Madkin, in cause number CR 21-3, you appeared before this court on February 4th, 2021, and you pled guilty to the offense of escape while arrested or confined. That's a 3rd-degree felony. The court heard the evidence by way of plea agreement and assessed your punishment at 10 years confinement in TDC. The court suspended that sentence based on your plea agreement and put you on community supervision for 5 years. In CR 21-4, on that same date of February 4th, 2021, you also pled guilty to driving while intoxicated, third or more. Punishment was assessed at 10 years and was suspended for a period of community supervision for 5 years. In each case, you were ordered to pay a $2,500 fine. During the period of your community supervision, the state has filed its motion to revoke your community supervision in each case. Have you had enough time to review that with Mr. Stevens?
Yes, sir.
And this time, Mr. Mackin, I'm going to ask you, how do you plead to count 2 in the escape while arrested or confined? There's only looks like there's only 1 count in that case. How do you plead to count 2? Guilty. Well, is that count true or not true? It's true. And in regards to the driving while intoxicated, the state has alleged count 2, 3, 4, 5, 6, 7, 8, and 9. As to those counts, 2 through 9, are those counts true or not true? True. And are you pleading true to those counts because the allegations therein are true? You're not just pleading true so you can get a certain deal. No, sir. Has anyone threatened, forced, or pressured you to make you feel like you had to plead true to any of these counts? No. Or will accept Mr. Mackin's plea of true to each of the counts as alleged in each of the state's motions. Mr. Stevens, any objection to the defendant's waiver of rights and plea of true as state's evidence? No objection. State's evidence is admitted in each case, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we arrest and close in each cause.
From the defense?
Resting, nothing further, rest and close.
We'll review the evidence. All right, Mr. Mackin, the court's reviewed the evidence. The court finds that you have violated the terms and conditions of your community supervision in each case. Court will follow the plea agreement that you've reached with the state. Court hereby assesses your punishment, revokes your community supervision. With regards to the escape while arrested and confined for a felony, assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice. Orders you to pay the balance of your financial obligations, including fines, court costs. Court also orders the sentence in this case to run concurrent with the sentence in CR 2024. For driving while intoxicated third or more, the court finds that you have violated the terms and conditions of your community supervision, hereby revokes your community supervision, assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders you to pay the balance of your financial obligations, and orders this sentence to run current with CR 2023. Mr. Mackin, you are awarded 211 days credits towards your sentence for the time you have spent in jail on each cause. Have you be fingerprinted with Deputy Police Sheriff? Is it just
not be excused. Good sir. Let's do this.
Wait, I think we need Justin.
We need Mr. Grubbs. Grubbs needs to say. Oh, he's not just on the restroom? Okay, yeah. Good.
Earlier, sent this to him. I don't believe there's anything he would have objected to, but I don't believe he probably yet. I just thought it would be easier to get the court to review it, sign it, and have it fingerprinted. If he has an objection, he can let us know. He only has 3 days credit. We asked Mr. earlier, and that's, he was arrested and bonded out 3 days later.
You appeared before the court on April 12th of 2018. You pled guilty to the second-degree felony offense of burglary of a habitation. The court heard the evidence, found that there was enough evidence to convict you, and the court followed a plea agreement that you reached with the state. The court deferred a finding of guilt, did not convict you on that date, and the court placed you on community supervision for a period of 6 years, and the court assessed a $2,500 fine. It was during your community supervision period that the state of Texas filed its motion to adjudicate and revoke, and they filed that on November 2nd of 2021. Have you had sufficient time and opportunity to review that motion and its allegations against you with your attorney, Mr. Ashmore?
Yes, sir.
You feel like you've had enough time to review that with him and have all your legal questions answered?
Yes, sir.
Are you pleased with Mr. Ashmore's representation of you?
Yes, sir, I am.
Is there anything about the paperwork that you've read and signed with his assistance that you do not understand?
No, sir, I'm fine.
Mr. Ashmore, do you believe Mr. Miller to be competent today?
Yes, Judge.
And you've explained to him his legal rights with regards to this proceeding?
I have, Judge.
And do you believe he understands them?
I do, Your Honor.
And does your client waive the formal reading of the state's motion to adjudicate?
Yes, Your Honor.
And is it his intent to plead true to all 12 counts?
Yes, Judge.
Your Honor, sorry to interrupt, but the state would be abandoning count one new offense in another jurisdiction.
You want me to strike through count one?
Yes, sir.
All right, so Mr. Miller, at this time, I'm going to ask you, how do you plead to counts 2 through 12 as alleged in the state's motion to adjudicate? Are those counts true or not true?
The truth, sir.
And Mr. Miller, are you telling me that the allegations are true because in fact they are true?
They are true.
And has anyone threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
Court will accept the defendant's pleas of true. Mr. Ashmore, any objection to the defendant's waiver of rights and plea of truth as state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of Mr. Miller's judicial confession. Anything further from the state?
No.
From the defense?
No, Your Honor.
All right, I see that Mr. Miller has reached a plea agreement with the state of Texas. The court will follow that plea agreement today. Court, in reviewing the evidence and accepting Mr. Miller's pleas of truth, finds that Mr. Miller has violated the terms and conditions of his community supervision. Court hereby adjudicates his guilt, convicts him of second-degree felony burglary of habitation. Court revokes his community supervision and assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay the balance of his financial obligations. Court finds that the state has agreed to abandon count one in the motion to adjudicate. Mr. Miller, you are awarded 206 days credit towards your sentence for the time that you have spent in jail on this cause.
Yes, sir.
And have you come forward to be fingerprinted with Deputy McLeish?
Yes, ma'am. Yes, sir.
Good luck to you, sir.
Thank you.
You say, right that way, I'll call your wife.
Thank you.
Just wait.
Stretch one, size of your push. All right, court's going to stand in recess for 10 minutes. All right, we are back on the record, CR 2164, State of Texas versus Justin Richard Grubbs. Court has considered the evidence and arguments of counsel. Court at this time finds that Mr. Grubbs has violated the terms and conditions of his community supervision. Court finds that each one of the counts alleged appears to be related to a drug abuse problem for Mr. Grubbs. Court finds that Mr. Grubbs has admitted in each one of these counts when he was smoking methamphetamine. Court finds that he failed to complete his drug offender education class within 90 days, and that would be related to methamphetamine use. The court finds that he was unsuccessfully discharged from counseling based on non-compliance. The court finds that to be related to drug abuse. The court finds that Mr. Grubbs, there's no evidence before the court that he has any other criminal convictions. Court, taking his testimony at face value, finds that he has complied with the other conditions of community supervision except for the ones alleged regarding payment of costs and community service restitution. Mr. Grubbs, I'm going to do something that I don't normally do. I look at your case and I think that you're due a second chance because obviously you have a drug problem. So I'm going to give you the opportunity that you've asked for. I'm going to send you to safety drug rehab. It's going to be a lockdown, locked up. It's going to be a 9-month to 12-month part of your life if you want to go. If you don't want to go, then I won't send you there because the people that go there, the ones that need to go there, are the ones that have a drug problem, admit they have a drug problem, and they want help with the drug problem, and they want to be taught how to deal with that. No use in you going down there if you don't want to go down there to actually get help and change your life. If I send you down there, are you going to go down there with the right attitude and go down there and improve yourself so that when you get out, you'll have the skills necessary to try to make it with your drug addiction? You need to talk to Mr. Ashmore. So feel free, take your time. Mr. Ashmore.
My client understands sorry. My client understands the option that's being laid in front of it. In fact, it's something we discussed before that the state and I couldn't get eye to eye on, which is why we're open before the court on this matter, and we're ready to proceed on that option.
And Mr. Grubbs understands that if I I extend this to him through my sentencing, that I expect him to go down there and diligently work to gain the skills necessary. What, in other words, I don't want him to go down there and waste a bed when someone else who wants to be there could be there.
Right. I think he understands that, and I've expressed to him that, you know, one of my turnaround clients, my only turnaround client, is a Safe P graduate. He was 21 years old, knucklehead, went to Safe P. Now we're almost the same age, right? He's now one of my best clients. He's a heavy construction operator, and he swears that Safe P saved his life. And I've explained that to Justin. He wants that shot.
All right, the court finds that Mr. Grubbs has violated the terms and conditions of his community supervision. Court finding the nature of the violations to be that related to drug addiction. The court is going to withdraw its finding that withdraw its adjudication of Mr. Grubbs' guilt. The court's going to continue him on deferred community supervision under the original terms of the sentence. The court is going to order him to do 83 days in jail as a condition of community supervision. The court is going to order him to successfully attend and complete the substance abuse felony punishment facility rehab. So, Mr. Grubbs, this is an opportunity that I want to give you. See that you don't really have any other criminal history. Through your testimony about trying to work, trying to do your community service, trying to pay, I'd be remiss if I just sent you to TDC. Okay, I could just send you down there and not worry about it, and let you get out and try to figure out your life on your own. But I'm gonna give you this opportunity. I think you're due it, so I'm gonna give it to you. So the ball's gonna be in your court. You go down there, you screw up, you get kicked out, you don't comply, you come back, you violate the terms of your community supervision. The next option will be where? Prison. And you're looking at up to 20 years. So I want you to be thinking about that every decision you make. Right? All right, that's the order of the court. I'd ask that we get a judgment regarding that. We're not going to adjudicate his guilt, but we're going to. I am going to find the violations to be true, and we're going to continue him on deferred community supervision. I'm withdrawing my adjudication of his guilt.
Judge, would you like a judgment and not just amendments?
Amendments, well,
Normally it is.
even when I find his violations to be true. Okay, that's fine. That's fine.
Safety in 83 days or something.
Safety, 83 days, ACOP, that should cover him from November 5th to today. All right, Ms. Burns is going to produce the amendment to your conditions of community supervision. Once you sign that, you're free to go. So, Mr. Grubbs, you're going to be held in the Van Zandt County Jail until safety is ready for you. And the average wait time is about 30 days. So once the paperwork is processed, then safety will be notified, and once they're ready to pick you up, they'll come down and pick you up from the jail. Okay, and so the time that you sit in jail from today until you get picked up, that would be credit time that you would get later if you're ever revoked or towards your participation. You understand? So are we clear with what my expectations are? Can you tell me what my expectations are?
Go down to St. Pete and do right. Get the help I need. Then finish safety and get out back out on probation.
Get back out. So when you go down there, you're going to be in classes. And they're going to teach you how to think. They're going to teach you how to avoid. You mentioned something about being around the wrong people. They're going to teach you about what are the factors that support your drug addiction. So you have to go down there. You have to learn. You have to change your mind. You got to change who you are. Because if you just go down there and you don't change, and you come back, then you're going to be right back in the same boat.
Sure.
So that's what my expectation is. That you go down there, that you become different through education and knowledge. And you come back and you apply that education and knowledge to your life. And that should help you succeed. You said you have a daughter? Son? You have a son? How old's your son?
He's 6.
He's 6.
Sure.
You think it's better with you in his life or out of his life? You think it's better for him with you in his life off of methamphetamine, or you in his life on methamphetamine? Off. Okay, so if you're not gonna do it for yourself, at least do it for him.
I'm not in his life right now because I was on methamphetamine.
Yeah, so you've lost him because of that. I've never met anyone that could tell me methamphetamine was more valuable than their son or daughter. I want you to think about those things. So you got a couple motivating factors right there, all right? But if you come back and you keep on doing drugs and not giving you an opportunity to rehab yourself, and you don't take advantage of it, the only recourse we'll have left is just figuring out how long you do in prison. That doesn't make you better, doesn't make society better, doesn't help anybody. Okay. All right, we'll be adjourned in this matter. I believe so. The ones that weren't here today, Casey Chester's clients, we've reset those until February 24th. We're going to send a message to Brittany Sherwood and Erica Simmons. Mr. Hunt had filed his motion for continuance. I believe Judge Thomas granted that. That's also set February 24th. I believe that takes care of everything.
Transfer my friends. I know that sounds like.
All right, that concludes our docket today. We'll be adjourned. Re-adjourned. Same time.